Something else that we have is a confidential letter of exclusion. So if you have really good reason why you wouldn't want your spouse or another family member, maybe you have a sister or a brother that you feel would want to take care of your children because of the life insurance that comes with that. We have a letter that you can write explaining to a judge why you wouldn't want that person to be a guardian.
Welcome to the Drama-Free Divorce Podcast. I'm your host, attorney and mediator Cary Jacobson. Each week, we bring you practical guidance, real conversations, and expert insights to help you navigate divorce with clarity, confidence, and less conflict. If you're ready for a calmer, more empowered path forward, you're in the right place. Welcome back. I'm your host, Cary Jacobson, attorney and mediator at Jacobson Family Law. And today we're shifting gears a little bit onto a topic that impacts every family, whether you're married, divorced, blended, or somewhere in between. And that's family protection and estate planning. I'm thrilled to welcome our guest today, Priscilla Castlebary. She's a personal family lawyer and passionate advocate for helping Latinx families preserve, plan for the future, and protect the people that they love the most. Priscilla, thank you so much for joining us today.
Thank you. So good to be here, Cary.
Before we dive in, I always like to ask our guests how did you get to be in the role that you are currently in? What led you to this practice of law?
It's a long story, but so I'm originally from Argentina. I came to the U.S. when I was 12 years old. I went to a lot of immigration meetings with my parents, being the oldest, having to translate for them. And so I always thought I would be like a great attorney. I really wanted to help families through their immigration process because I went through it myself. And so I always said, I want to be an immigration attorney. And that was like my number one goal for going to law school. But before going to law school, I worked at a law firm because I wanted to make sure that law was something that I would enjoy, before spending those 3 very stressful years and spending all that money going to law school. So I worked at a law firm, and in that law firm, we had a case of a father that had a 4-year-old, and he worked installing mirrors, and one of the mirrors fell on him and killed him instantly. And so Child Protective Services took the child, and our firm was representing the grandparents of the child that lived in another country. We had to prove that they had money, in their country. If he went to live with them, that they could send him to a school where he would learn English as well as the native language and all kinds of things. 2 years went by. Nothing really changed in the process. It seemed like the judge and the social worker were kind of not sure what to do with this child. And so I was like, there has to be like an easier way for this to happen. And so I think didn't think about that case anymore until my last year of law school, that I took wills and trusts. And then I saw how easy it is for people to leave instructions for a judge or for somebody else to take care of their families, their children, their assets. And I was like, why isn't anybody talking about this? That's when I was like, okay, this is going to be an area that I wanna practice, and I wanna educate people. So I do free presentations for the community so they get this information that I feel like it's needed by everybody, because we're all gonna die. What is it that I say? Taxes and death are inevitable, and we all have a plan, which is the state has a plan for each person. So you do have a plan, and your plan is not a good plan for you. So giving out this information is something that I'm very passionate about.
That's an incredible story, because there's always something, right, that brings us to the field that we choose to practice in. And just for our listeners, I think what you're saying is that even if you don't have a will or a trust of your own, your state, wherever you may be, has default laws that's going to step in, that's going to basically say who's going to take care of your kids and what's going to happen with your assets, unless you create that estate plan yourself, where you put your own wishes in your will or your trust.
Exactly. Yeah. So that's one of the questions that I love to ask people. Because I'm like, okay, raise your hand if you have a plan, an estate plan. And so the people that created a will or a trust raise their hands, and everybody else, they don't. And I'm like, no, everybody should raise their hand, because you all have a plan. That it may not be the one that you chose for yourself, but you have one.
Right.
No, I
absolutely
want to know what that plan entails.
Right. And who's going to take care of your kids if, something happens to you and or their other parent.
Exactly. You're leaving so much of that up to somebody else, right? Because now a judge is going to sit there and look at your family and decide what's the best place. And he doesn't have all the information that parents have, right? He just meets these people and he sees them on paper, but maybe somebody that's good on paper is not the person that you would choose or, to be with your kids. You know them better than a judge would. And I think that's one of the biggest problems is that they don't have all the information and they may make the wrong choice.
This is for anyone, whether they're married, single, divorced, widowed. But I want to talk specifically about families where the parents are recently divorced. Why is it so important in those scenarios for those individuals to then create an estate plan or update one that they may already have?
Yeah, so important. There recently was a case of a person that died and had not updated his life insurance. And I don't know if you heard about it. His ex of 25 years, like they dated for like a few years, 25 years ago. But she was the beneficiary and she got all of his life insurance because he never updated that. Yeah, so important for people that once they get divorced and they have that separation of assets, it's important to set out like guardianship because now you may not agree on the guardians. Something important to know about that is that the fault will always be the other parent if you like him or not. So one of the questions that I get from people when specifically for guardianship is, do I have to agree with my ex-spouse about who's going to be the guardians? And the answer to that is no. As long as you know that the default will always be the other parent, you can set up your own wishes. You don't really have to agree with the other parent. And then, obviously it would be great if you do agree, if you both have like the same wishes, but you don't necessarily have to, because I know some divorces, they just can't agree on much. And not naming guardians is not a good option if you can't agree. So try to work together on naming guardians, but if you can't, you can set up your own and your spouse can set up his own as long as they know that you will be the default too if something were to happen. But yeah, naming guardians, super important when it comes to that. Changing all the beneficiaries of your life insurance, retirement accounts, super important to do as well.
Absolutely. So I want to go back to a couple of things you talked about, one being the life insurance policy and also retirement. So I've seen scenarios where even if someone has updated their estate plan and they've gotten divorced and they've divided their assets and they still don't go back and change those beneficiaries on the life insurance policy or the retirement account. As you mentioned, you could live another 10, 15, 20 years. And if you don't update those things, whoever is named as the beneficiary is going to be the one to receive those funds. And I think sometimes people expect, well, I did my estate plan and somebody else in the will, or I've done my divorce. So why would they be the person to get it? But you have to update the beneficiaries.
Yeah, those are two separate documents,
Right.
The life insurance and retirement, those kind of go outside your usual estate unless the beneficiaries are minors. And so just because you updated your estate planning documents, yes, it doesn't mean that your beneficiary designations, have changed. So you do have to do that unless you named your trust as a beneficiary, and then just changing stuff on your trust would be enough in that case. But I do know a lot of people that, they have named already, their grown-up kids or something, and they don't want it to go through the trust. So they already have those beneficiaries, named.
Absolutely. And then I want to go back to, you were talking about guardians earlier. So just for our listeners who may not necessarily know what that means, can you kind of briefly explain what a guardian is and kind of what that role is for kids that may live after you have passed away?
So usually on estate plan, what we do is name short-term guardians and long-term guardians. So these are the people that will take care of your child if something were to happen to you. The short-term guardians for us is people that are within 5 minutes of your house, that if something were to happen to you, they can show up right away with a letter from you saying that you give authorization for them to stay with the specific person. And then long-term guardians, now these are the people that you're choosing for your kids to live with long term. In some cases, these could be the same people, right? If they live in the same space. But for most people, the US is just a place where families just are all over.
Right.
And so most people have friends close by, but family members that they would want to have their kids further away. And so what we're trying to do is not to have like Child Protective Services take the child. So by having somebody within 5 minutes with authorization to stay with them, we can make sure to show that to, Child Protective Services or the police, so that they know that you can stay with the kids, and then they can stay with that person until the long-term guardian can come and get the kids.
Got it. That makes complete sense. Okay. Another question that I have that I think comes up regularly, and you were kind of talking about this as far as like the default parent. Or the default guardian. So if a couple gets divorced or separated and something happens, let's just say something happens to mom and mom passes away, even if mom put in her will that she wants her sister to be the guardian of the children, unless there's some reason why biological dad is unfit, then I think what you were sharing is that biological dad in that scenario would be the default guardian of the children, correct?
Yeah. And that's the way, the law works. Obviously, we're not taking kids away from biological parents unless there's a really good reason or the parent declines to take care of them. Something that we have for our clients, it's a kids protection plan that includes all of these things: the short-term guardians, the long-term guardians, instructions to babysitters, right? We leave our kids with babysitters, and when something happens, the first thing that they do is panic and call 911, which means that the police comes and now they have to call Child Protective Services. So the instructions basically tell the caregiver, make sure you call one of the authorized people to stay with the children before you call the police. So that when they show up, the short-term guardian is already there with their document. And we also have cards that will go in our client's wallet that say, I have minor kids waiting for me at home. If something happens to me, reach out to these people that are authorized to stay with my children. Something else that we have that goes kind of with what we were talking about is that confidential letter of exclusion. So if you have really good reason why you wouldn't want your spouse or another family member, maybe you have a sister or a brother that you feel would want to take care of your children because of the life insurance that comes with that, or with the money that comes with that, but not because they would be good guardians to your children. We have a letter that you can write explaining to a judge or to somebody else why you wouldn't want that person to be a guardian, and it's completely confidential, and it won't ever come out, or the person won't ever find out that you wrote it unless they're fighting to be the guardian of your kids. So it's completely confidential unless this person is coming forward to want to take care of the kids.
Very interesting. I think those sound like great additional pieces of the plan so that everyone's kind of taken care of and protected, so that the kids are protected.
Right. Yeah. Yeah. So important to have, because some people, and I'm glad to say most people are like, no, there's nobody in my life like that. But I've had people say, yes, I definitely have to write that about my mother-in-law or something like that, So yeah, it's a good tool to have just in case you need it.
Right. Well, we talked about divorce being one of those times when people need to create or update a plan. When are other times that you strongly recommend people either create, which is always, or update their estate plan?
Yeah, for sure. So starting at 18, once your kid turns 18, they need a power of attorney, a healthcare directive. These things are so important because they're now considered an adult under the law. And so you don't have a right to their information anymore. And so if you wanted to be informed, like if they get in an accident while they're out, in school, having a healthcare directive is great for that. I've seen it also for financial reasons. The kid is being super irresponsible at school with their money, and the parents don't find out about it until they got kicked out because, they had failing grades, or they didn't pay the money that was supposed to go to pay for the school.
Right.
And then I'm getting spent on other things. And so that's a good way. Obviously, now at that point, the 18-year-old would have to name you, right? It's not just because you're the parent and you can't make those documents for them. Like they have confidentiality with an attorney, and they would have to pick you themselves. But other than that, it's important to have those documents. Also, when you get married, it's important to update your estate plan and make sure that now you're including your spouse. We talk when you get divorced and when you get married again. Blended families is one of the biggest problems that we see when it comes to estate planning. Because then, the kids are fighting with a stepmom that you're spending all the money that my dad left me. And yeah, we see all of these issues that could totally be prevented when you create an estate plan. You can protect inheritance to your kids from a previous marriage while still making sure that your new spouse has enough to, live and everything they may need. So yeah, estate planning is great to make sure that there's no fighting in the family after your death when you have a blended family situation. And I would say the last one is when your spouse dies. Once your spouse dies, is going to go talk to an attorney and make sure that things are being owned, properly when it comes to your assets and that, just reviewing. But I would say overall, I think it's a good rule of thumb to just review your estate plan every 3 years. As your life changes, your estate plan should too. I think most people create an estate plan and in their mind, they mark it as like, checked, did that, don't have to worry about that anymore. And then their life changes. They have kids, they get, married or get divorced and their plan doesn't reflect, or they move and then they have they sold the house that they put in the trust and it's empty now. So yeah, those are all good seasons to make sure that you change it. But every 3 years, I think it's a good rule of thumb.
Yeah, I agree with that rule of thumb of just checking it out, just making sure that, everyone that you have named in your estate plan is still relevant. Yes. They're still appropriate individuals to carry those roles and that it still reflects, your intentions.
I recently had a presentation when I was talking about this, the lady was like, oh my gosh, the people that I named as guardians, we haven't talked to them in over 10 years.
Right.
And yeah. And she was like, I never updated that. A lot of people also had more kids since they did their estate plan. They're not named in their plan at all. Mm-hmm. I get a lot of people that name guardians and then the guardians got divorced, and so now they didn't update that. So yeah, for sure, you need to make sure that you check all of those stuff because life changes.
Absolutely. When I wanted to go back to something else you were referring to, which is the blended family. And we see it all the time. People have gotten divorced and now they're getting remarried, whether it's a couple of months after or years later.
Hopefully not.
But people need to be aware of is that in many states, you also need to consider a prenuptial agreement to go along with the estate plan, because in many states, Maryland being one of them, which is where we're located, if you're married and do not have that prenup, then your new spouse is automatically going to be entitled to a portion of your assets, and you can't necessarily give it to your kids if that was your intention, your adult children or what have you. And so the prenup or postnuptial agreement, because sometimes that happens, you just didn't get around to it, and the estate plan really work in tandem with one another. I don't know if that's the same where you're located.
Yeah, for sure. And I know prenups have such a bad rap, right? I have a lot of people that when I talk to them about creating a prenup before they get married, they're instantly kind of like offended, maybe a little bit, because they're like, okay, you're already planning for the demise of this marriage and we haven't even gotten married yet. But I think definitely in those blended family situations, it's not about, they also, some of them get married later on in life. So the person maybe has already built a business that maybe took a hit with the first divorce, that everything got split half.
Right.
And now they're wanting to protect that. They're wanting to protect it for their kids, or they're wanting to protect the kids from a previous marriage. There's so much that can go on. So you have, you could get married and then not have new kids in the new relationship. Other people do had kids in that new relationship. But I can tell you that expecting that your spouse will do the right thing is not a good plan. I've seen that fail so many times where, they were like, what we thought, I really thought that she was going to do the right thing or that he was going to do the right thing. And they really don't. So it's important to use tools such as a prenup to make sure that your kids are protected, or there's options in a trust too, in which you can protect part of your inheritance to go to your kids while your spouse gets to enjoy the other part. There's ways that you can protect from your spouse. Like if this is your first marriage, there's ways in which you can, through a trust, protect the assets for your kids, so that if your spouse gets remarried after you pass away, you make sure that the assets that you had with your spouse will go to your kids and not any kids that they may have later on. And so,
Or to their future spouse.
or to their future spouse. Yeah. Yeah. So yeah, these are all tools that you can use to make sure. And that's a wonderful thing about estate planning. It's like there is no wrong way to do this. You have so many options. It just really depends on what are your goals, what are you trying to achieve, and there's definitely a way that we can do that through your estate plan.
Absolutely. No, I know that you specifically work with Latinx families, and that's something that you are passionate about, you being from Argentina originally and, coming from that world. What are some unique challenges or misconceptions that you see working with first generation or immigrant households when it comes to estate planning?
Oh my gosh. So I think I would rephrase that to say that I am passionate about informing Latinx people, about really working with them, because it's so hard to get them to see the value in estate planning. I have a lot of American families that they instantly know because their parents have done it. I have a lot of people come to me because their parents told them, hey, you need an estate plan. With the Latino community, it's so hard to get them to see that because culturally, they're afraid to talk about death. Once you talk about it, you're kind of calling it. I feel like also they've been in survival mode for so long that they don't see the value in doing this. They're just used to surviving. But so many of them have businesses that definitely need to be protected, for their families. And family is huge in our culture as well. So making sure that there's no arguments when you die, it's such a huge thing. I've seen it, and I'm sure you've seen it too, of families that they don't talk to each other anymore. Or sometimes what we would consider like pretty, dumb, unimportant things. Like it's not even about money sometimes. It's about like a chair or a china, So,
something that your parents were going to give to you and you felt like you were slighted or something along those lines. Yeah.
Yeah. Yeah. And so I feel like death and money do weird things to people. I've heard and seen people that are usually very level-headed, pull up to the house with a U-Haul after the funeral, like literally right after the funeral to take stuff. And then that caused problems in the family. So yeah, having stuff set up and said specifically of what will happen and who you want stuff to go to honestly saves your family. And that's what I tell my clients too. It's like, what we're doing today, you're not going to see the benefits of it because, you'll be gone, but your family will thank you. Because a lot of the clients that I have, they've either come to me because their parents didn't have an estate plan and it was a nightmare to deal with. Yes. Also, some of them come to me because their parents did have an estate plan and it was so easy and they were able to grieve without having to worry about going to probate and about, how are we going to pay for the mortgage? All of their accounts are frozen, all of those things. And so, yeah, I really not having an estate plan will bring clients and parents that did create an estate plan that was super easy for them to deal with. Also, they come to me and they're like, this is what I want for my family.
Right. Because I don't want to put my family through what I was just put through, or I am so thankful that my parents did it this way. And I want to be sure to do it the same way for my family.
Yes.
Yeah.
Yes, for sure.
Now, I'm wondering, we were talking about those folks who are divorced, but is there anything special about unmarried couples, people who are never actually married, but do have children in common with one another? Is there anything specific that they should be considering when they're creating their estate plans?
Oh my gosh. Like, I feel like they're the number one people that should create an estate plan, because when you are married, a lot of stuff, like what I tell my clients is like, we're looking at what would happen if both of you die. Because when you're married, kind of everything goes to the other person as a default. So, what we're really setting up is like, okay, what happens if both of you die at the same time, or one of you dies shortly after the other one, where, you don't have anything you don't have any time to fix your estate plan. But when people are not married and they have kids in common, each other is not the default. So when you're naming guardians, well, I mean, the mom would be the default in that instance. But if you're like at the hospital and you wanna, who's gonna make the healthcare decisions for you? Your spouse is not the default, but you're not married. So now it would go to like a family member that they can find. And then what if the family member your spouse doesn't agree with what your family member is doing or what decisions they're doing? I'm sure also the living partner probably knows better what are the type of care you would want in in a healthcare situation, but they don't have the power to do it. So if you are living together but you're not married, it's so important that you create an estate plan to make sure that your spouse has a voice and a vote when it comes to your care in healthcare or the house that you own, because sometimes that happens. It's like one person had the house and the other person just moved in, but was never really added to the title. They're not married. So if something were to happen to the person named on the title, the other spouse doesn't have a right really to stay in the house.
Right. The other person that they're
yeah.
Right. Yep. I know it gets a little confusing. Now in Tennessee, I think that's where you're located. Do you have the option of a domestic partnership? Is that something that is recognized?
No.
Okay. So that is something that Maryland has, that even if it's unmarried couples, they can enter into a domestic partnership, which is another option that gives them some benefits. It gives them some inheritance rights, so that let's take that jointly owned house, right? Then when one person passes away, the other owner would not necessarily have to pay inheritance tax on that. So they can receive that property without having to pay inheritance tax. They can also, while they're living together and while they're, in that domestic partnership, can also even benefit from having medical insurance on the same plan.
Wow.
So I think it's just something for our listeners to be aware of, because, this actually just came up very recently with an old client. We worked with them to do her divorce, and now she's in a new relationship. They're not necessarily intending to get married yet because they just haven't gotten there, but they've bought a house together. They both have adult children from a previous relationship. And so it's kind of an interim scenario. So they can enter into this domestic partnership until or unless they decide to move forward and get remarried. Yeah. But I would just say, check with your particular state, because certain states allow that as an option.
Yeah. And if your state doesn't, then, you need to decide, I guess, sooner rather than later if you're going to get married or not. And if you decide not to, an estate plan is definitely way to go, because I've seen the arguments between the families and the living partner, where they go to court and they're suing each other, and and it just causes so much more stress in a time where you're already in a stressful situation, and then when the person dies, it's even more stressful. So what we're trying to do, is give our clients peace of mind to know that if something were to happen to them, their family is protected. They'll know exactly what happens. I mean, I'm a control freak by nature. I need to know what happens. Right. There's a lot that I can't control, but if I can control knowing what happens to my child, what happens to my spouse, making sure that my child is protected, if my spouse gets remarried, then I will definitely want to set that up and make sure that, I know what's going to happen, and I set up what are my wishes.
Absolutely. Well, Priscilla, this has been such an insightful conversation. Thank you so much for sharing your expertise and shining a light on the importance of planning ahead and controlling those things that we can control. For listeners, if you would like to learn more about Priscilla and her work, Priscilla, where can they find you and your services?
Yeah. So my website is www.rcalawfirm.com. And you can find me on all of the social media platforms as the Latina Mom. So THELAWTINAMOM.
Wonderful. And if you need help navigating the divorce divorce or co-parenting without all of the drama. You can find more resources at our website, which is jacobsonfamilylaw.com, or listen to past episodes right here. And be sure to like and subscribe so that you can find the most recent episode. Don't forget that you don't have to navigate the divorce alone. You can get through this peacefully. Until next time. Thanks for listening to the Drama-Free Divorce Podcast. If you found today's episode helpful, be sure to follow, subscribe, and share it with someone who needs it. For more resources or to work with us, visit jacobsonfamilylaw.com. Until next time, stay grounded, stay informed, and stay drama-free.